And sometimes, oftentimes, a veteran client wants you to know how badly this particular disability is affecting their life. Understandably, justifiably.
Yep.
Sometimes that's not the first question for the VA's purposes.
That's
and
right.
So the question becomes, why are we focusing on service connection, right? This legal question, as opposed to explaining to the VA how much help I need. Does that make sense?
Sure.
Yeah.
It does. And I know, we've both had clients that have expressed that, and the answer is pretty simple. It's because of the legal requirements. The judge can't get to the question of what the symptoms are and what the rating is unless and until he or she can find service connection. Moreover, typically when we're presenting these at the board, which is really what we're talking about here, the judge is probably not, in most instances, going to try to make a rating decision based on the symptoms. Instead, he or she is going to decide to grant or deny service connection. And if service connection is granted, the board is going to remand.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Tony Francis Jackson.
Welcome to Victory Over VA, our podcast that is your guide to unlocking veterans' disability benefits. If you're a veteran applying for benefits, be sure to subscribe for the latest developments in VA disability. I'm Francis Jackson. This is Cliff McCarthy. We're veterans disability attorneys at Jackson and MacNichol, where we've helped thousands of veterans to win millions of dollars in benefits that were due them. We created this podcast as a resource for veterans applying for disability benefits, but it's for everyone. It's for anyone who is a friend of a veteran, relative of a veteran, or simply wants to support our veterans community. The purpose of this entire podcast is just to provide understanding about disability benefits that are available to our veterans. And today, we're going to talk about a favorite subject. Why does my attorney do X? Take it away, Cliff.
So, a question I get sometimes is, why do you, or why as a previous attorney, choose not to submit every piece of evidence I provide for my VA disability claim?
Sure. The answer is pretty simple. The purpose of the submission in a VA case is to guide the judge to a favorable decision. And sometimes extraneous kinds of evidence can be distracting. Sometimes there's a particular focus that you want to bring to the claim that some pieces of evidence simply aren't helpful to or aren't relevant to. So the question is always, how do we focus this claim in a way that lets the judge understand the basic points? As you know, Cliff, and as our listeners have heard me say before, there are three elements to a veteran's disability claim. We have to show something that happened in service, we have to show a current disability, and we have to show a medical connection between the two. And so the focus is always going to be what pieces of evidence take us in a fairly straightforward manner down that path for the judge. And if there are things that are related but don't really help us to focus right down that path for the judge, sometimes we leave them out.
Sometimes what's required for a claim to be successful is not exactly what common sense might hold. So sometimes we have to explain common sense does not always have a central place in the law, right? There's things that the judge needs to hear, and that might not be exactly what is in the record. So that's another reason why we have to sometimes tailor the submissions.
That's exactly right. As you point out, certain claims in particular have very specific requirements for the judge to grant the benefits, particularly with increased rating claims. There may be some very, very specific things that we have to prove. So, there's no point in burying those specifics in a mass of generalities. We want to focus and guide the judge right to the central issues that he or she has to decide to render a favorable decision for the veteran.
So along the same lines, a lot of veterans sometimes ask, why are we only focusing on certain claims or certain questions? Right?
Sure.
Not everything all at once.
And there can be multiple reasons for that, but a couple of the most common, some claims simply don't have much potential for monetary benefits. Tinnitus, for example, is limited in the VA system to a rating no higher than 10%. And if a person already has a significant number of ratings, an additional 10% may, because of the way the VA does the VA math with the combined rating table, not offer any benefit at all. So it's important in every case to look at the big picture and to figure out which claims will actually drive a reasonable level of benefits for the veteran and to focus in on those. By the same token, sometimes there are cases where certain claims have very specific proof issues that we may not be able to make. For example, if somebody's suffering from both depression and PTSD, because of the specific rules about how you have to prove stressors for PTSD, it may just not be possible to prove service connection for PTSD, whereas we can definitely prove service connection for depression. So in those circumstances, the focus would be on the depression claim rather than on the PTSD claim, because our goal is to get justice for the veteran, to get him or her the benefits that they're entitled to. And we're going to shape the presentation to focus in a way that is most likely to get those benefits.
The way I always put it is we want to do always two things: obtain the highest possible rating and secure the earliest possible effective date. Hidden in there is a third thing, which relates to what we're talking about now, is to achieve those two ends as quick as possible, right? With
That's
the least
right.
path of resistance.
That's right.
So if that means focusing on less than every claim, then that's what
Sure.
that's what happens. That can explain some of the attorneys focusing on some of the claims at the expense, it feels like, at other claims.
Absolutely. I mean, if we can see a way to get the veteran paid at the 100% rate by focusing on certain claims, then that may be the best path in that case.
Another question I had: why does my attorney not always respond to every point made in a VA denial letter?
Well, the answer to that one's pretty simple. Sometimes some of the things the VA says in the denial letters are really irrelevant. They have no legal significance. And so when you're presenting the case to the board at a hearing, the board judges are all lawyers. They're all specifically legally trained. They're supported by a team of attorneys who are legally trained. And if the regional office got hung up on some issue that really has no legal significance, it may well be ignored in the presentation because it has no significance.
Right. You're dealing with experts at the board level, and so you can afford to really do things strategically at the board level.
That's right.
Yeah. We've gone over an aspect of this, but why do some attorneys recommend leaving out certain details of my medical history in the hearings?
Again, it's a question of focus. Because each claim that you can make for the VA in terms of benefits has specific requirements either because it's in the VA's rating codes or because it's being rated by analogy to a rating code. There are only certain things that the proof will help with. So, for example, with diabetes, the issues become things like, is the person required to use insulin? Or is the person required to restrict their activities? So things that don't help to get to the points that the VA requires for the rating sometimes just get left out because there's no benefit to presenting them, and they kind of muddy things up. That's a poor choice of words, but the object is to make the presentation as direct as possible. And the less you have to fill in a lot of extraneous detail that the judge has to go back and then filter out to reach his decision or her decision, the better.
Right. And this goes to, we've been talking about right now, focusing the issues.
Yep.
A question I get a lot is about, once we got the issues narrowed, what are we doing with it? And that is, sometimes veterans wonder, why are we prioritizing obtaining certain medical expert opinions over others once we got the issue narrowed and we know what we need to establish?
Sure, because even if we're going to include all the claims that the veteran wants to advance, and obviously if the veteran feels strongly about any or all of his or her claims, we're going to advance them. There are certain ones that are most likely to either, number one, need medical support as opposed to just testimony about I have these symptoms, or are most crucial to building the case in a way that's going to get the benefits. So if, for example, a person has a whole series of claims, but one of them is a claim for TBI, traumatic brain injury, that claim alone, if it's properly presented and rated at a high enough level, will get the veteran 100% or being paid at the 100% rate. And so even if the veteran feels strongly about some other claims, a left knee injury, for example, it's probably not worth asking the veteran to have to pay for another medical evaluation on the left knee just because we're already spending the money and making the effort to get the opinion about the critical claim in this hypothetical of the TBI. That would be why.
Right. And sometimes, oftentimes, a veteran client wants you to know how badly this particular disability is affecting their life. Understandably, justifiably.
Yep.
Sometimes that's not the first question for the VA's purposes.
That's
and
right.
so the question becomes, why are we focusing on service connection, right? This legal question, as opposed to explaining to the VA how much help I need. Does that make sense?
Sure.
Yeah.
It does. And I know, we've both had clients that have expressed that, and the answer is pretty simple. It's because of the legal requirements. The judge can't get to the question of what the symptoms are and what the rating is unless and until he or she can find service connection. Moreover, typically when we're presenting these at the board, which is really what we're talking about here, the judge is probably not, in most instances, going to try to make a rating decision based on the symptoms. Instead, he or she is going to decide to grant or deny service connection. And if service connection is granted, the board is going to remand the issue of what the correct rating is and how severe the symptoms are back to the regional office. So all that happens if we spend a lot of time on the symptoms and explaining to the board how much help the veteran needs is it has the potential to get in the way of letting the judge focus on the critical legal issue, which is service connection or not.
Speaking of focusing, even once we've gotten all the issues narrowed down to the narrow legal question, and we know what facts we're going to focus on and not focus on, what evidence we're going to emphasize and de-emphasize, sometimes the veterans wonder, well, we have a hearing, why can't we discuss all of these carefully narrowed issues?
And the answer to that is because of the strange way that the VA does things. They only do these claim by claim. And what happens is the VA processing, if you will, often separates claims so that by the time you get to a board hearing, you may only have 2 of the veteran's 7 claims that are eligible for the board to determine. 2 other claims may be at the court, another one may be pending on a supplemental claim, another one may be pending on a higher level review, and there are only 2 that the board can do anything with. So the focus will be, even though we know that overall there are 7 different claims that we want to try to win for this veteran to get him or her to the maximum benefit, only 2 of them may be eligible for decision by the board.
Speaking of the court, it used to be that if you got a bad decision from the board, you had to appeal to the court.
Right.
That's not the case now. And so sometimes we'll take a different route than going to the court. The obvious question is, are we giving up? Are we doing something? Are we leaving benefits on the table? Why aren't we appealing to the court when the board says no?
Sure. Under the change in the law that became effective in 2019, the AMA as it's called, the veteran has a choice, a set of alternatives in how claims are presented. And at the level that you were just discussing, where the board has made a decision, there are 2 options. You can proceed to the court, which is what you essentially had to do before 2019. But now you also have the opportunity of filing what's called a supplemental claim. And if you file a supplemental claim within a 1-year window from the date of the board decision, you can require the VA to go back and look at that decision, even though the board has already turned it down. You can require the VA to go back and look at that decision, and you can submit, in fact, you have to submit additional evidence to explain why they should look at it again. But the point is, you have the opportunity to look at what the board decided, to figure out where they thought the problem was, and to submit the claim again as a supplemental claim with evidence on the points that they thought were not supported. And that has the effect of keeping the original effective date so that you're not leaving any benefits on the table. The benefits, if granted, will go back to the original date of the filing, just as they would if it was remanded by the court.
Now, going from the court back to the board, a question I get a lot is, we've narrowed the issues, you've talked to an expert, you've obtained some evidence. Why are we not submitting this report right now? Why are we waiting till after we talk to the judge?
Well, the answer to that is, if it's an AMA case, we're not allowed to submit it now, which is a silly rule and unfortunate, but that's the rule. So the way it works with AMA cases, the only opportunity to submit evidence is in 2 pieces. You can submit evidence on the initial claim up to the point that the VA makes a decision, the regional office makes an original decision. And then on appeal to the board, there's another opportunity. If you are in the evidence submission lane, it's a period of time right after you file your appeal. If you're in the hearing lane, you have a 90-day window right after the hearing to submit the evidence. But those are the only options for submitting evidence. Once that evidence is in, the record is frozen, if you will. It goes up to the court on an issue, it gets remanded. That doesn't reopen the opportunity for adding new evidence in AMA cases. And if it's an old case that's still in the legacy system, then you can add new evidence after remand. But in the new system, in AMA, the case is decided from February 2019 on, there is no opportunity to submit this evidence. What we have to do at the board is convince the board that there was an error, that it needs to be sent back to the regional office for a new decision, and at that point, we can submit the evidence to the regional office. But there's no window, there's no opportunity at the board. We can only submit argument explaining why they ought to send it back and get it developed.
So a lot of veterans and that I speak to, they can offer up a dozen people who know them personally and who can explain just how much help they really need. And that seems obviously relevant on its face. Why is it that we can't, or why do attorneys sometimes not want to incorporate everybody's input?
Sure. Well, I think there are a couple reasons. One is just from a practical point of view, most of the cases that we're talking about are about service connection. As a very general rule, and there are obviously lots of exceptions, the cases that we're taking to the board are about getting service connection. Usually, if the board grants service connection, the actual considering all the symptoms and figuring out what kind of help the veteran needs and so on, we'll go back to the regional office. So usually we're at the board about service connection. So there are two considerations there. One is that we want to make sure that we don't convey to the judge that we're trying to gild the lily here, that we're trying to overdo this. We want a straightforward presentation. But in addition to that, one of the things that happens if you have 10 people talk about the same thing, they all say it a little differently. And sometimes those differences matter in terms of the legal effect. So we want to make sure that whatever we present, we do it in a straightforward, consistent manner across the board. We don't want to bore the judge with extraneous presentations, and we don't want to muddy the waters by having people talk about it in different ways that sound like they may be in conflict, even though they're actually consistent when you get the whole picture. But it's often easier to keep it all consistent if you are focused and use just a few witnesses.
Now, once we get the issues narrowed, once we got service connection, once we got a rating, why is my attorney so focused on my work history or ability to work or other questions about employment, not, the way the disability hurts or feels or something like that?
Sure. One of the best benefits, I think, that the VA makes available in the disability area is something called TDIU. That just stands for Total Disability Based on Individual Unemployability. That particular benefit allows the VA to say, okay, you have a bunch of service-connected disabilities, and when we put them all together, it shows that you're not able to work. And if you're not able to work, and we can find that you qualify for this benefit, TDIU, we can pay you at the 100% rate, the maximum benefit that's available. So one of the key pieces for eligibility for TDIU is showing that the veteran can't work. It is less about the symptoms they have and how disabling they are than the fact that the combined symptoms, combined conditions that are service-connected, collectively keep the veteran from working. If we can get over that hurdle, we can get the veteran paid at the highest possible rate, at 100%.
Great.
Thank you very much. I appreciate the opportunity to present this podcast today, and we hope that you'll ask all your friends and colleagues to share this episode and to watch our podcast, and we'll look forward to seeing you next week.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.